Hello, John. How are you doing?
Hey Sam, boy, there were a couple of killer modal guitar solos in that. I loved that.
Yeah,
Right?
that's one of my favorite songs. But Shamash, if BB King ever found out that you associated his visage with Warren Haynes, he would have another heart attack and die. So just
Nah, I'm just
just saying.
I was just scrolling through the gifs. That wasn't mad. I just wanted to show that I'm really into the tune. I really like the tune. Just for the record.
Good. For those of you interested, that was Stranded in Self Pity by Warren Haynes, one of my favorite electric blues musicians. So before we start today, basically the slides are as usual linked at the top, and please follow along. John and Shamash, anything we should know before we delve in?
Well, only you know, because I mentioned in the last room, I'm going to have to take off here pretty soon because I have to have my teeth lowered by my dental hygienist or raised or whatever it is they do. So, oh, I
Well,
may
good
be able to
luck.
listen. Maybe I'll be able to listen while I'm having my teeth cleaned. We'll see.
Yeah. Well, good luck with that. And Shamash, do you have any news for us before we begin?
Not really. No news. Just enjoying the rooms in the Scientific Discourse Club. If you're not a member of the club and you're interested in everything cool, especially good music, sign up. We are
Yes.
also live on YouTube, so I will paste the link in the chat now.
Okay. Sounds good. Well, welcome YouTubers to Scientific Discourses and Intellectual Property. So this is going to be our first initial foray into patent law. Today is mainly just introduction to patent law. What are patents? Some of the kind of philosophical underpinnings that we do in patent law. And then in the next few weeks, we're going to go through the specific laws that govern the practice of patent law and talk about some of the case law that that deals with all of that. So, slide number two, that's kind of the outline for this whole series. We finished our conversation for trade secrets last week, and hopefully, you guys enjoyed it or got something out of it. And so, this week is patents. And so this slide shows the four areas of intellectual property law: trade secrets, patents, copyrights, and trademarks. And what is it that each area protects? So we see that trade secrets, they protect commercially valuable secret information. Patents protect ideas. Copyrights protect expression of ideas, and trademarks protect correlation between goods and services and their source. And we've also said that patents and copyrights were the original intellectual property. Trade secrets, as we discussed, started out in torts and recently became a, an area of law unto itself. Patents and copyrights, as we see later, uh, originally were put into the Constitution, and trademarks came up later out of the English common law, and its inclusion in intellectual property domain is not without
Sam,
its critics. Yes.
um, I'm blasting my volume to the maximum and I can barely
Ah.
hear you.
Okay.
Is
Let
there a way that you can raise the
me.
volume from your end?
Is this better?
Oh, much better. But
Okay.
there's quite a noise like something watery behind you.
Yeah. Hold on a
I don't
sec.
know. Find some sweet spot.
Is
Turn
the
that
water
fan
gone?
off. Yep.
Okay. Yeah, I had the fan on. So now the fan is off.
Yeah, now it's
So
perfect.
is it much better now?
Oh yeah, definitely.
Okay, great. I'm glad you said that. All right. So how do this comes up in patents quite a bit, not as much as we discuss copyrights or the other areas of IP on slide 3. We see that intellectual property can be used in both offensive and defensive ways, the same way that a cannon can have both offensive and defensive uses. So how can a cannon be defensive is that on the picture on the left, you're an invading army. You come up to this wall and you see those cannons and you say, guys, the other city that's another day to the west doesn't have those cannons on the walls. So let's skip this one and go maraud the other city. And so in this way, the cannons on the wall basically scare the enemy away, saying that the cost benefit analysis for storming the walls isn't going to work out. And on the right side, we see that cannon can be taken to the field, and you can go chase after your enemies in an offensive way. So if an enemy has invaded your land, you drag your cannon and start shooting at them to push them out of your land, or to somehow go over there and take over their land using your cannon. So we can see that a cannon can be used both defensively and offensively, and a patent also in the business world can be used both defensively and offensively. So this is a very famous refrain that all patent lawyers learn in law school, that a patent can be a shield and a sword. So how's it a shield? It's a shield like on the left. It defends your territory by making people look twice before coming in. And it's a sword because you can go after your competitors who you think are infringing on your invention. In description of patent law, unfortunately, we use a lot of martial analogies, attacking and weapons and war and this and that. Mostly because the philosophy is basically the same, right? It's you're going to war, but it's a trade war. It's economics, but so we kind of given that all patent lawyers in the past were nerdy males, they do use martial language quite a bit. So where do patents and patents in effect come from, and why are they called patents? Patent is short for letters patent, and patent means visible and open. The antonym of patent is latent, which means hidden behind the surface. So some older people pronounce them patents to rhyme with latent. We don't do that anymore. We all say patent and latent. So what were letters patent? Letters patent in medieval times was that you would, as an artisan who had invented something, a process, a machine, whatever it was, and you wanted to have exclusivity in the use of your invention, you would apply to the king. And the king would issue a letter saying that this guy at the shop has exclusive rights to use this invention. And that letter had to be placed in a prominent position in the artisan's shop, so anybody who would enter would see it, so that they would know to keep their hands off of the process that the artisan was using. And because that letter had to be prominently displayed, it was called letters patent, a prominently placed letter. The term of the medieval patent was 14 years, and that was because each period of apprenticeship was 7 years. So the master was allowed to enjoy a monopoly in that invention through 2 cycles of apprentices, and then those apprentices couldn't compete with the master using that invention until that 14 years was gone, and then they could enter the competition. The United States took this medieval concept of patents, and this is really one of the brilliant moves that the founding fathers had. I really don't know who had this idea. That's something that I should search, but to put intellectual property into the Constitution. So on slide 4, we see the constitutional clause. Article 1 is the article that deals with the legislative branch, 2 being the executive branch, 3 the judicial branch. So Article 1 talks about what Congress and how it's organized and what it does. Section 8 is the section that gives the powers of Congress. And Section 8 starts out with the Congress shall have power. And then it's followed by a whole bunch of clauses. The 8th clause is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is called the Intellectual Property Clause of the Constitution. Recently, it used to always be called the Patent and Copyright Clause of the Constitution. You may remember from very early on in the series that we say the term intellectual property is a modern term. That is, it really started out in use in the 1990s. Before that, we didn't really have intellectual property as a coherent concept. We had patents and copyrights, etc. But that coherent concept of intellectual property started out in the late 80s, early 90s. And so this was historically called the Patent and Copyright Clause of the Constitution. And in slides 5 and 6, I'm going to point my pointer to some interesting things here. On slide 5, you see that it says, for limited times, the exclusive right. So this is basically what we call a limited monopoly, a monopoly that is limited in both time and scope. The time is limited based on what Congress decides the time is, and the scope is limited to their respective writings and discoveries. And then in clause 6, we're going to kind of deconstruct this using grammar a little bit because of a terminology that will become common as we discuss patent law. So it says progress of science and useful arts to authors and inventors, respective writings and discoveries. So when you deconstruct this, authors write science and inventors discover arts. This is absolutely proper using 18th century English. where science was referred to what today we call the humanities, philosophy, literature, things like that, where the sciences, and arts were what we call engineering, especially useful arts. This is why people who made things in their shops were called artisans, because they made stuff. So inventors discover or invent useful arts. We will see the term art used in patent law over and over and over and over and over again, and so we should from now on know that art means a scientific field of endeavor, as I have shown in slide 7 as part of some of the vocabulary that we use in patent law. So useful arts are science and technology. An art, or the art, is the field of endeavor. So we say the art of chemistry, the art of mechanical engineering. A piece of art is a disclosure, whatever disclosure might be, it's a piece of art. And prior art is a piece of art that was made before the invention. And how you would define invention, that is based on law. Today we call the invention as the date of the invention, as the filing date of the patent application for that invention. So prior art is basically any information that existed before you filed your patent application. Of course, next week, as we discuss section 102, we'll see that prior art has a much more nuanced definition than just being made before the date of the invention. But for now, we say prior art is a reference that came before you filed your patent application. So when you go through the examination process, the examiner rejects your claims based on prior art, meaning that it says such and such reference disclosed what you talked about. One of the most common mistakes that are used by lay people is that they say, we filed a patent. You don't file a patent, you file a patent application, and that patent application will mature to a patent. That's a lot of patent attorneys' peeve, that people say, "Oh, we filed a patent." No. You didn't file. You filed a patent application. We're wordsmiths. Words mean a lot to us because we basically live in the world of words. So we get very nitpicky about the misuse of words. In addition, so some other vocabulary stuff. This is also a patent prosecution. It causes a lot of confusion because lay people, when you hear prosecution, you're like, well, prosecutor, courtroom, trials. But patent prosecution doesn't mean courtroom or trial at all. Patent prosecution means the process of obtaining a patent from the patent office. That's patent prosecution. So it's a transactional legal work, not litigation. Patent litigation is when you sue or you defend for patent infringement. And patent lawyers generally divide themselves into patent prosecutors or patent litigators. A rare breed does both, but that's very rare that you find a patent attorney who does both prosecution and litigation. Most of the patent prosecution people do litigation support, meaning that they review the file history of the patent, they review all the communications with the patent office, etc., to see if there was any anything amiss at the patent office for when they were trying to get the patent. So they don't actually go to work or write motions or any of that. They support the litigators. So how do we use patent prosecution in a sentence? We say during patent prosecution, a patent prosecutor prosecutes a patent application. What does that mean? It means that during patent prosecution means during the pendency of a patent application. Pendency means it's before the patent office, application has been filed, patent has not been issued, so that the patent application is pending. During the pendency of a patent application, a transactional IP attorney who is admitted to practice before the United States Patent and Trademark Office, that's a patent prosecutor, corresponds with a patent examiner to remove rejections of patentability. That's prosecuting a patent application. So these were just vocabularies, and so what? Why is the U.S. government giving the inventors this limited monopoly in their discoveries and inventions? It's because in order to get a patent, you have to disclose basically everything you know about that invention. Not everything you know, but enough to allow one of ordinary skill in the art. That's another term that we hear. It's either person of ordinary skill in the art, posita, or one of ordinary skill in the art. And art, we said, is the field of endeavor, and a person of ordinary skill in the art is person who is average in their skill in that technical field. So your patent application should allow one of ordinary skill in the art to be able to make and use the invention. So you have to, we'll get to that when we talk about Section 112 in much greater detail. But just to say here is what I've put on slide 9, that the inventor makes a deal, a quid pro quo, a give and take with the government. The government gives the inventor a monopoly limited in time and scope, and in return, the inventor discloses everything they know about the invention. So that way, for that limited time, the inventor can enjoy the fruits of their invention, but once that time is over, the whole world will now have access to the information that the inventor had. So knowledge is expanded by giving you this monopoly. Overall knowledge and is expanded, and technology advances forward. So this quid pro quo, this give and take between the government and inventor, is the underpinning philosophy behind that Article 1, Section 8, Clause 8. It is this quid pro quo that the founders thought, quite correctly, as history has shown, that's going to promote the progress of science and useful arts. And we've seen that again and again, that this has been the case. Any questions so far before I move on? All right. So let's talk about the anatomy of a patent. Sorry, the type is small. I wanted to fit the whole thing on a page, the next 4 slides, but you can probably make it bigger. So on page 10, we have the first page of a patent. This is called the face page. The face page has all the administrative information about that patent. So on the top left, we have the last name of the first inventor. On the top right, we have the patent number and the issue date of the patent. Then below that is the title, then the name of the inventor, the name of the assignee, who owns this patent. So Dr. Mehdi Poborji was the inventor, but Theravita Inc. Was the owner of this patent. Then there's that notice for patent term adjustment. We'll talk about that later. Not to worry about that here. Then it's the application number, what date it was filed, when was the application first published, what are the prior applications that this claims priority to, and then what's the international class and subclass for this invention. Then the international class and subclass is pretty interesting. So the thing is that, one class would be pharmaceuticals, another subclass would be, pharmaceuticals dealt in this area, or pharmaceuticals that have this core structure, etc. And so what is class subclass? That allows the examiner to do an in-depth search into the subject matter of the patent application. So the examiner reads about the invention in your application, and the examiner then assigns an international class and a subclass to that, and then they will search in that area. In the old days, before computers, and this kind of carried over into when I started in patent law in 1997. This was still a thing until computers kind of became a lot more prevalent. This was called, the examiners did what was called in-shoe searching. IN and then shoe, as in what you put on your feet. Because in the basement of the patent office, there was the archives of references. And each row was dedicated to one class. And inside of that row, there were shoe boxes, because shoe boxes are good for 8.5 by 11 size paper. So there were shoe boxes. Each shoe box was associated with one subclass. And so when the examiner wanted to do a search after assigning the class subclass, they would go to the basement, find a shoe box that had all the references for that class subclass. They would look through those. And if they found a reference somewhere else, they would assign a class subclass to it, and they would put it in that shoebox for future searches. So we still do that in shoe searching, but this is now all computerized, and we don't actually have shoe boxes. Then on the top right, we have all the references. In this case, it continues on a second page, but I didn't show you that. So it's all the references that the examiner considered in determining whether this application was new and non-obvious. Then below that, who did the work, the examiner and the attorney. Yours truly's name is there. And then the abstract and one of the drawings. So this is the face page. This gives you really all the information you need to, all the administrative information you need to know about the patent, as in where is it filed, how do you calculate the term, who was the inventor, things like that. After this comes a whole bunch of drawings. There, as it says, I have 11 claims and 7 drawing sheets. I'm not going to show you any of the drawings because they all look like the drawing we have there, which is a graph for the pharmacokinetic or the effect of the drug on saliva output in patients that has to do with the invention here. But then on page 11, we begin the body of the patent. This is called the specification, the body of the patent. That's the technical term for it. And it always starts out with the title and then related applications, what's the priority of this, then background of the invention gives us kind of a context for why we're doing this, and then summary of the invention. Depending on who the patent attorney is, that summary of the invention has a certain format. There are different ways of doing this. And then brief description of the drawings, that those 7 sheets of drawings that we had. This would basically be the kind of underneath each drawing says what the hell this is. And then detailed description of the preferred embodiments. This is where the meat of the patent begins. That is, we basically talk about what the core structure of the drug is that we're going to use, and then how are we going to do it, etc., etc. And then I have spared you a whole bunch of pages. One more thing, when you want to reference a patent, as you see on top, each column has a column number. And in the middle, between the 2 columns, you have line numbers. So you say, patent so-and-so, column this, line that to that. That's how you reference a section of the patent. And so we jump to column 17 on slide 12. You put in examples of how this invention was used. Here I've shown you case example 4, which is a case study for a combination of oxybutylene and pilocarpine. This is kind of a clinical trial that was conducted. A rough and ready clinical trial. This is not an FDA clinical trial. This is a kind of a doctors in their offices doing that, because both of these drugs were already approved by the FDA, and so doctors can prescribe them as they wish. So in this case, we put together the study protocol and reviewed it with the doctors, and they conducted it. At the end of the patent are claims. We see here it starts column 23, line 5 on slide 13. So let's say you have a property and you want to describe your property to me. You say, oh yeah, I have 4 acres, and there's a barn, and then there's a manor house, and there's a creek that runs through it, and there are a couple of boulders and trees, and things like that. That doesn't tell me that describes your property to me very clearly. I can actually picture that property in my head and know exactly what it looks like, but I have no idea where it is. I don't know if where I'm standing, I'm trespassing on your property or not. Where would I be trespassing on your property? And so in order for me to figure out when I'm trespassing, I go to the county clerk's office and get the deed to your property. That deed says absolutely nothing about where the trees and the boulders and the barn and the creek and all that are, except it gives me the 4 corners of the property. It says the property is from this point going easterly for this many feet or yards, and then, right? It basically tells me what the borders of my property is. And so if somebody wants to know whether they're trespassing on my property or not, they don't go read the description that I wrote. They go look at the deed. They go look at the boundaries of the property. They go look at the metes and bounds of the property. And what determines those metes and bounds? That's METE, metes. What determines the metes and bounds of the property, that is the deed. Claims at the end of the patent are that deed. They are the claims determine the metes and bounds of the invention. So if I read claim 1, and the way you read the claims is that they all start out with what is claimed is, or I claim, or we claim, or it is claimed. And then followed by sentence fragments. So the whole thing makes a full sentence. What is claimed is a pharmaceutical composition comprising a therapeutically effective amount of oxybutynin or tolterodine, or a free base thereof, or a pharmaceutically acceptable salt thereof, and pilocarpine, or a free base thereof, or a pharmaceutically acceptable salt thereof, wherein the oxybutynin is present in a dose of between 1 milligram to 30 milligrams, tolterodine is present in a dose of 0.1 to 50 milligrams, and pilocarpine is in a dose of between 1 milligram to 30 milligrams. So it doesn't really matter what else I have written in the specification of my application. All that I have in the specification of my application are where the trees are, and or here are the trees, here's the barn, here's the manor. But it is this that says my invention is a combination of oxybutynin with pilocarpine, or tolterodine with pilocarpine, where in that combination, if I'm using oxybutynin, the dose is between 1 and 30 milligrams. If I'm using tolterodine, the dose is between 0.1 and 50 milligrams. And regardless, the dose of pilocarpine is between 1 to 30 milligrams. So if you're outside of these doses, then you're not trespassing on my land. It doesn't matter if in the specification I have put in the dose goes up to 100 milligrams. That is just a description that I've given. What determines the actual metes and bounds of my invention, what is legally binding to everybody else, are the claims. When I go sue someone, I compare their invention to my claim language and then determine whether they're trespassing or not, whether they're infringing or not. The rest of the patent, as we'll see in section 112, provides us with the ways to make and use this invention, and also describe this invention, and tell us how is it that we know this invention works. That's the body of the invention. So here, I actually have two inventions in this patent. One is claims 1 through 7, and those are directed to the pharmaceutical composition, and claims 8 to 11 are directed to a method of treating overactive bladder in a patient, comprising administering to a patient in need thereof a therapeutically effective amount of the pharmaceutical composition of claim 1. So here my invention is both the drug and the method of treating a patient using that drug. So that's the anatomy of the patent. Those are the different sections of the patent. Other types of inventions have other sections. So for example, if your invention was funded by a US government grant, then you have to disclose that in the first line of the patent, because the US government will have some rights in the patent if they choose to exercise them. If this is a patent that discloses sequences of amino acids or DNA or RNA. You have to have a sequence listing chart, things like that. But basically, what I have shown you here is the basics of all patents. All patents have to have these sections. If they don't, the examiner will ask you to revise it and put these sections in it with the proper headings, etc. Any questions on that? Did I go too fast? Was it the right speed? Was it understandable?
No, it was perfect. We're following along. It's great.
Sounds good. Thanks. All right. So let's, starting on slide 14, talk about claims for a little bit. Slide 14 shows the structure of a claim. It has a number followed by space, then you have a preamble, transition phrase, then the body. So a device comprising a body and a plunger. Here, the number is 1. Preamble is a device. Transition phrase is comprising. Body of the claim is a body and a plunger. So what is a transition phrase? So on slide 15, there are we have 3 transition phrases in patent law: comprising, consisting of, and consisting essentially of. What does that mean? If I say a device comprising a body and a plunger, meaning that any device that has a body and a plunger would infringe this claim. It doesn't matter what else it has. It could have, 5,000 other things in it and just had a little body and a plunger in one part of it. That whole thing infringes your patent because that device comprises. Comprises is called an open transition phrase, meaning that it can have the details in the claim and a whole bunch of other stuff. The second one is consisting of. Consisting of is a closed one. A device consisting of a body and a plunger. This consisting of means that it has a body and a plunger and nothing else. It's only a body and a plunger. So if I put a bell on the plunger, then I'm not infringing you because now I have 3 things, and the claim says just consisting of. You can have those 2 things and only those 2 things. The third one is a device consisting essentially of a body and a plunger, meaning that if the bell that I put on top of it is not essential to the function of this device, say it's a decorative thing, has nothing to do with what we want to do with the body and plunger, then we say it consists essentially of that body and plunger, meaning that the components that are required for the function of this device are the body and plunger, and only the body and the plunger. Everything else is not essential for the function of that. So if you say that, no, the component that you have is essential for the function of what you have, then you won't be infringing. Just to make sure, we haven't really actually gone into any patent law yet. We're just talking about vocabulary that's used in patent law. We have different types of claims: independent, dependent, and multiple dependent. An independent claim is complete in and of itself. So a device comprising a body and a plunger. It doesn't reference anything else. It is a complete unit. And independent claims always start with an A. dependent claim is a claim that references a previous claim and incorporates all of its limitations. So claim 2 says the device of claim 1, wherein the body is made of aluminum. So the dependent claims always start with the because they specifically reference a particular device. We're not talking about any old device, we're talking about the device of claim 1. So how do you read this, the device of claim 1, wherein the body is made of aluminum? You read it as the whole thing. A device comprising a body and a plunger, wherein the body is made of aluminum. You can also claim it alternatively, saying the device of claim 1 or 2, wherein the plunger is made of plastic. So again, you read it as a whole, a device comprising a body and plunger, wherein the body is made of aluminum and wherein the plunger is made of plastic. Or you can say the device of any one of claims 1 through 3. And then these are more complicated forms of claiming a device comprising means for expunging fluid from a body. That this is called a means plus function claim, which has a whole body of law associated with that type of claiming itself, because a device comprising expunging means to remove fluid from a body is a completely different claim than a device comprising means for expunging fluid from a body. They refer to completely different things. You can have in the exact same patent application, you can have both claims 5 and 6. Their scopes are going to be completely different. They're going to be referring to completely different things, even though when you're looking at it, they're like, well, as far as English grammar is concerned, they're exactly the same. But as far as patent law is concerned, they're not. And we may talk about that. Just say means plus function has to have this means for functioning language. So if you don't have, in claim 6, I have functioning means. Functioning means is not means for functioning. And so that is what tells me means for functioning. And then that limits the means for functioning to whatever means that I have disclosed in the patent application. So it's limited to that. But expunging means, functioning means, it could be any old means for doing something, even the ones that I have not disclosed. So you could be infringing claim 5 but not infringing claim 6, or vice versa. Okay, so what's the term of a patent? We said initially in the medieval times in England, it was 14 years from the issuance of the letters patent. In the United States, initially it was 14 years from the issuance of the patent. For design patents, that is still the term of the patent, 14 years from the issuance. And we have kept that because design patents are not governed by international laws and treaties, whereas what we call utility patents, patents that when I tell you a patent, you think of a utility patent, the one that I showed you now, which goes to the use of the idea, usefulness of the idea, as opposed to the design of of whatever it is you have. And so these are governed by a great deal of international treaties, and so the term for those are different. So what is the term for a patent? It's on slide 17. It is 20 years from the earliest priority date. It doesn't reference any other application. the filing date of the application is the earliest priority date. So if the application was filed on January 2nd, 2020, that application expires on January 2nd, 2040. And it doesn't matter how long it takes at the patent office from the time A is filed until A is issued. Here it took 3 years and a month for the application to issue. It doesn't matter. The term of the patent is measured from the day you file the application, and it's 20 years from that. We can have continuing applications. A continuing application is an application that basically discloses the exact same thing that the first application disclosed, but has slightly different claims. Remember, I said I have claimed two different inventions. One's the pharmaceutical composition, the other one method of treating a patient using that pharmaceutical composition. I could have broken those up, and in fact, in that application series, we broke it up many different ways, and file a continuing application. So you basically file the exact same application as before, but you change the claims. That one, because its disclosure is identical to the disclosure of the parent application, it is not as though it was filed on the day the parent application was filed. So because it is claiming priority to that, its effective filing date is going to be the filing date of the parent application, and so the parent application becomes its earliest priority date. So a continuing application, in this case application B, was filed 3 years after application A, but it doesn't matter. It still expires on January 2nd, 2040, because the first application was filed that day. I can continue doing this. I can now file C, right? And I file C 10 years after the first one was filed. It doesn't matter. This, again, issues on January 2nd, 2040, 20 years after the filing date of the earliest priority date. This continuing practice is, or continuation practice, or divisional practice, it all means basically the same thing, is very important in the United States, is a really big part of our strategy for how to pursue patent protection for an invention. In foreign jurisdictions, it's a lot more difficult to do continuing application as we do here. So foreign practice takes a lot more thought as to, okay, how am I going to claim this? What aspects am I going to claim? How am I going to position this to be able to create the right conditions so I can file a divisional later? You know, all of that stuff. So for foreign stuff, the strategy becomes a little more complicated, because in the US, you can freely file continuing applications up until the expiration date of the first application. When we talk about patent terms, we have to talk about provisional applications. So what's a provisional application? To understand why we have provisional applications, or what provisional applications are, we first have to see why we have them. So prior to 1996, foreign applicants in the United States had a 1-year advantage over US applicants in the United States, meaning that if I'm a French citizen, I can go ahead and file a French patent application, And that doesn't start the, it starts the clock on the French patent, but it doesn't start the clock in the US. Instead, what does it do is that it puts the flag down for prior art determination. So any information that becomes public after your filing date of your French application is not considered prior art to your application because you have already filed your patent application. All foreign applicants, and that's true for US applicants in foreign jurisdictions, at the 1-year anniversary of their local patent application, they can enter that into any other jurisdiction they want and claim priority to it. So they come in and file a US application claiming priority to the French application. So now the French person has an application that for prior art purposes has 1-year advantage over the US application. The US applicant doesn't have that. The US applicant will have to file a US application. So it's basically the foreign applicant gets a 21-year patent term, whereas the US applicant gets a 20-year patent term. So this was considered unfair, and as part of the GATT negotiations in 1995, that's the General Agreements on Tariffs and Trade, Uruguay round, they created this thing called a provisional application. And the only 2 major jurisdictions use this provisional application scheme, and that's the US and Australia. And the US is really the biggest one because we do get a lot of foreign originating patent applications in the US. So the competition for patent term is a lot more intense in the US than it is in Australia. So what does a provisional application do? A US applicant is allowed to file a provisional application to set their priority date. That application doesn't get examined, doesn't get looked at. It just sits there on a shelf and it automatically expires at the 1-year anniversary of its filing. So within that 1 year, you can then complete your invention, cross all the T's, dot all the I's, and then at the 1-year anniversary, file your US application and claim priority to the provisional. So now this puts the US applicant on the same footing as far as patent term is concerned as the foreign applicant. The provisional practice is not recommended across the board. Provisional practice is very, very good in pharmaceutical inventions because in pharmaceuticals, what's important, it's a terminal term of the patent. At the beginning of term of the patent, you're stuck in the FDA, you're stuck in, regulatory stuff, you're trying to build your distribution, and et cetera, et cetera. After the drug has been in the market for like 10 years, that's when it's going like gangbusters, and that's when you want to have patent protection. So in pharmaceuticals, you try anything you can do to increase the length of the protection for your pharmaceuticals. But in the electronics, no. I mean, 20 years from now, the electronics that you're using today is going to be a museum piece. So for electronics, it's the front end of the patent that's very important. So you want to file a patent application and get the patent issue as soon as possible so that you can protect the longest term of the product on the market using that patent. And so in like electronics, nobody files provisionals. They just file a U.S. application, and they do all the things that the patent office allows you to do to accelerate the issuance of the patent. For pharmaceuticals, we just let it sit there and not spend any money on it until we're getting close to hitting the road with the drug. Any questions? We've gone through a lot of stuff, patent term, claims. Okay. So the last two slides, I'm going to introduce the laws, the statutes that we use. So what's the difference between a law and a statute? A law can be promulgated. It can be put together by either the legislature or the courts. And so you can have legislative enacted laws, and you can have common law court enacted laws. And so statutes are laws that the legislature enacts. So when Congress passes a bill and the president signs it into law, that's a statute. So patent law is statutory law, meaning that it is governed by statutes. And on slide 20, I have put in order of importance and order of usefulness the types of laws and regulations that we deal with on a daily basis. So on top is the U.S. Constitution. That's the most important legal document that we have, but it doesn't give you anything, right? You can't practice patent law using Article 1, Section 8, Clause 8. So under that is the United States Code. What's the United States Code? It's Congress given constitutional authority in an area, passes legislation. That legislation is either kind of has a permanence to it, or doesn't have permanence to it, and that is how is that determined is kind of anybody's guess, but usually after a law sits around for a while, it becomes codified, meaning that the publishing house of the United States government will take that law and will put it under a section in the already existing laws, and will publish the United States Code with that law in it. So you would see that a piece of legislature that gets passed, it affects many, many different codes, meaning that it says, such and such USC such and such is amended this way, because every single subject has multiple different areas of law that deals with it. So when Congress passes a law, it tries to make it uniform across all code sections, and so a legislation will affect many different code sections. But a single piece of legislation like America Invents Act or Obamacare, something that isn't amending previous laws, that stays by itself, and then it's codified, for example, under the whatever title deals with United States Health Code. It becomes a section under that. So we'll see that in trademark law, where the legislation that was passed to give us the federal trademark law is called the Lanham Act. But when it got codified into Titles 41 and 43 of the United States Code. So it kind of got split apart. So the code is basically what Congress passes in order to make the Constitution workable. The Constitution by itself is not functional. So you can't sue on the Constitution without having any legislation that that deals with that. Because you have to say this law doesn't follow what it is that the Constitution says. So you always sue on a legislation, on a statute, on constitutional grounds, but you can't sue on the Constitution because the Constitution itself is not operational. It has to become operational through the act of Congress. So it's a United States code that makes the Constitution functional. And then you go to the agency and you say, all right, how do you implement this law? Because the statute doesn't tell you how to implement it. So the agency sits down and figures, okay, when the law says you need to do that, you need to file this paper, you need to provide this information, you need to pay $15, all that stuff that actually on the ground makes the law functional. That is, it's like the question of, all right, you do patent law, you do this, you go to your office in the morning, you turn on your computer, now what? What do you do? So that is the Code of Federal Regulations. That is promulgated by the agency itself, and it tells you how the agency is going to implement the law that Congress passed based on the Constitution. Up until here, the USC and CFR, this is true for everything in the executive branch. All agencies in the executive branch have their own CFR, the Code of Federal Regulations. In the Patent Office, we have one additional document, which is the Manual of Patent Examination Procedures, or MPEP. This is a manual that tells the examiners what to do with the code, with the CFR. So basically, the lesson that you learn here is the higher up from the ground you go, the less functional the law becomes. So it's really MPP that tells you you need to submit Form 81-20 and within 20 days from, such and such. And if they don't do that, the examiner issues a rejection that says this, and that. So basically, when a patent attorney is dealing with the patent office and is saying, okay, what do I do now? We go to MPEP first. And we say, well, what does MPEP say? How is the patent office viewing this issue? What is it that they consider to be a complete submission in such and such thing? And then and then you can challenge that, right? In your writings, you can use the higher level law to challenge what the MPEP says or what the examiner's interpretation of the MPEP is and all that. So that all goes into your legal arguments. So basically, we, in order to figure out what to do, we always start with MPEP, because in there it also lists the applicable CFR section and lists the applicable USC section. So you know that this section of the MPEP gets its authority from those sections, and so it helps you out quite a bit. Last slide is basically I'm just introducing the 5 code sections, Title 35 of the United States Code. These 5 code sections run the entire world of patent law. Yeah, in litigation, other stuff would bring in code sections for procedural things or interpretive things, all of that, but they're all based on these 5 code sections. So section 101, the gatekeeper section tells us what types of inventions would be patentable. So actually this is patent eligible. I should change that. We'll talk about the difference between patentable and patent eligible next week. 102 tells you how do you determine if an invention is new. Section 103 says even if your invention is new, how can we tell if it's not an obvious variation of an old thing? Section 112 tells us the body of the patent application, what requirements it has, and 271 is what does it mean when one infringes the patent. So in the next few weeks, we're going to go through these code sections one by one and kind of look at the nuances, the ins and outs. What do we mean by new? What do we mean by patent eligible? What do we mean by obvious? All of that stuff has about 200 years of case law that determines what every word means for now until somebody else comes in, changes it. All right, I'm done with what I wanted to say, and so I'd like to invite people to come up, or Shamash, Ben, who are already up. Let's have a conversation going.
Fantastic, Sam. Thank you. Can I say, is it okay if I say I'm enjoying this series more than the chemistry one? Is that offensive?
No, not at all. Not at all. This in fact is what I expected. And hey, I left chemistry lab to get into this, right? So it means that I find this a lot more interesting than the chemistry thing too, because to me this is where rubber meets the road, right? I mean, you do your chemistry thing, but now what? This is what helps you commercialize it, get into the business, get into the economy, get into commercialization, right? I mean, it's this that kind of makes the chemistry come alive when you do patents. Other than that, it's just dry experiments.
So, question. I heard and I hear continuously many times when I'm looking into random stories. Oh, there's this invention in the 1930s and now so-and-so company owns the patent for it. There's this whatever name from very old, and now today, this company inherited it. And then in your presentation, you said it's 14 years or 20 years or something like that. So question, in what way is owning a brand or owning the invention or owning the name of something different than a patent? And number two, can the owner of that patent pay some money or do something to extend their ownership, or is it just that 20 years?
These are really good questions. So first of all, if you're talking about 1930s, the ownership is not a patent ownership. It's either trade secret ownership, like the Coke formula, or it's copyright ownership, like Disney, or it's trademark ownership. So it's not the actual patent ownership because, as you correctly said, patent ownership has a limited time of now 20 years from.
So it's just a name. It's a trademark. It couldn't be something that has to do with
Or it
an
could be the
actual
trade
patent.
secret that's associated with it.
Oh yeah.
Yeah. So that kind of stuff. And no, you cannot, once something gets patented, you can't patent it again. But what is that something that got patented, right? So I can maybe change the words and the claim, and now that something is what we call patentably distinct from the something that we patented before. Maybe we can now patent that, but that becomes it is not an easy thing. So, what is my expertise in patent law? My expertise is what we call life cycle management. Meaning what? Meaning that from the time the company comes up with the core structure of what they think the drug will have, that core structure, you start the patenting process. You still don't know what your compound is, but you start that. So then you have your compound, you do that. But I mean, the problem is that by the time the actual API, the active pharmaceutical ingredient patent expires, you're probably still in the FDA, or you have come out of the FDA in 1 or 2 years. So how do you ensure patent protection for that drug sufficiently so you can recoup your investment? That's where I come in. That you manage the commercial life cycle of the drug using patenting, so that the drug at every stage of its development and commercialization has a patent associated with it that prevents generic companies to come in until you run out, right? You can only do so much, and then the generics come in after that. So that is done in the pharma business quite a bit. As I say, some people like me specialize in that and how you play those games. Other technologies also have similar kind of life cycle management games that they play. For example, I know this is done in computer science and electronics quite a bit, but that is not my area of expertise. I can't really tell you how they do it in those technology spaces. So I hope that I answered your question.
Yeah, absolutely. Can I ask one more?
Oh, sure, yeah.
So you work in a pharmaceutical company, right? And you're in charge of protecting whatever they come up with via writing this complicated sort of patent paper where you detail things in it so that other people cannot claim that they have a generic. So you're protecting their intellectual property by drafting such a document. But what if you messed up? Like, what if, or not you messed up, what if another lawyer from another firm outsmarted you as a lawyer and still figured out a way that you missed, still figured out some combination, some wording, some whatever for something very, very close, or probably exactly the same as the product that your company manufactures? Are you responsible? Can they sue you now because, well, we charged you with this and you didn't do it? Or is it like, oops, sorry, we lost billions of dollars now because the patent doesn't work? What's the situation here?
So it's not a one size fits all, because The facts can be a lot more complicated than that. Was the point that the opponent used, was it foreseeable at the time that you drafted the patent application? If it was foreseeable, then there's an argument that you committed malpractice because you didn't include what was foreseeable. Was it foreseeable? You discussed it with the client, and then the decision was not to include it. Did you not see it at all? Should you have seen it? Right. So that becomes really complicated. The majority of the time, patent attorneys include everything that's foreseeable. In fact, every patent attorney, if you really think about it, is going to be an inventor on every patent application that they have written because they add so much more meat to the invention that the inventor hadn't realized, and that's because we've been doing this for so long. We know what all the variations are. We know how people will attack an invention and things like that. So we add a lot more details to the invention that the inventor hadn't realized that could be added. But we're not supposed to call ourselves inventors because everybody understands that's what a patent attorney does. And so what got missed, was it something that the inventor also missed? I don't have to come up with things that are in addition to what the inventor told me. And so, well, was it missed? Was it because I missed it, or is it because the inventor missed it? So these are very, very fact heavy calculations that you have to do. That said, half of my job is to figure out how to blow the competitors' pants out of the water, right? So the thing is that the patent office makes mistakes, the prosecuting attorney makes mistakes. When you're prosecuting a patent application before the patent office, you have very limited budget. When you're attacking a patent, you basically have an unlimited budget. You can do all sorts of searches that you couldn't do when you were prosecuting a patent application and attack it using prior art that neither the applicant found nor the patent office found. So yeah, we're constantly trying to invalidate each other's patents. And it happens, and it's kind of like, well, shit happens. It's you can't protect yourself against everything. So yeah, people will eventually come after you if you're successful, and will come after you. I mean, if you're not successful, then nobody cares. If you're very successful, it doesn't matter how beautiful of a job you've done. People will infringe it. People will walk all over you. So we kind of know that. Both I know that, and my CEOs know that. So, and my boards know that. So that's, everybody's playing this game.
All right, cool, understood. Many thanks, and again, great series. I never imagined myself I'd be interested in learning law, but you're making this fun, so thank you.
Thank you. Ben, Hero, Plutos, welcome to the stage.
Very interesting, Sam. Yeah, very clear. Most of it very clear. Some of the acronyms that I hadn't stored went over my head. So where you were back-to-back acronyms, then that was, I couldn't follow. But otherwise, a lot of it was very clear. Good analogy. So thanks.
Can I just say hi to Ben? I haven't heard his voice for a while. So hi, Ben.
Hey, man.
Actually, there are three acronyms you need to know, and those are all on slide 20. For now, I mean, come on, we're dealing with law, right? We're just all sorts of names and acronyms and Latins and all sorts of stuff. But the most important from this presentation, they're on slide 20. Hello, Hero. Hello, Plutos. Do you guys have any questions?
Yeah. I may have one question for the hot topic of the day, Sam. Perhaps one is like what factors do you consider when evaluating trade secret versus patent protection for AI innovations, per se.
Unfortunately, I don't know much about AI stuff. That is not an area that I practice in because I mean I say that and and my company is an AI company, but I don't deal in the machine learning stuff. I'm in the biology and biochemistry part of it. So I'm not really sure how these things will play out with AI inventions, and so if you want to like make your question broader, that I may be able to answer that.
Okay, yeah, like how do you like when do you advise clients to choose trade secret uh you know protection over patent protection is I guess.
Yeah. So the first thing is, where are you in your development cycle? How close are you to commercialization and for the product to get out? The further away you are, uh, it's better to protect it with trade secrets rather than patents, because if you're in the early stages of development, chances are that the product, by the time it becomes a commercial embodiment, it will have changed. So you will protect that using trade secrets until you kind of have a good idea of what your beta is for going into the market with. The other consideration is how crowded is the field? What are your competitors doing? If it's a very crowded field, everybody is almost at the point of stepping on everybody else's toes, then you file a patent application immediately because somebody else is going to beat you to it. If it's something that's easily reverse engineerable, you patent it. If it's impossible to reverse engineer, no, why would you want to pay all that money to get a patent? And also, patents have a certain lifetime. Trade secrets are theoretically unlimited in term. So that's another consideration. The other one is how quickly does the product evolve? It takes, on average, 3 to 4 years to get a patent. If within 3 to 4 years you've changed 3 or 4 versions, then it's not worth patenting. So this is what happens with a lot of the game apps. Initially, when apps came out, everybody was like, "Oh, we should patent this game," but then they're like, "Why? In 3 months, this game is passé. Nobody's going to play it, and we've moved on to the next one." So people stopped patenting games. So it really has to do a lot with what the market looks like and what your business plan is and what the technology is. you can't give it a you have to analyze that on a case by case basis.
Oh, okay. And then Ben brought up acronyms and said to look at the other acronyms, but maybe another question is like, how's the levels of patent, law hierarchy, like like USC, CFR, Constitution, I think another one's NPP, how they create practical challenges for practitioners is maybe another question if that's relevant to the acronyms.
So you can't. It's very difficult to cite the MPP in a litigation to the judge unless you're trying to say that, look, what I'm saying is not crazy because even the patent office says this. Then you show them the MPP. You within the agency, you can have quasi-judicial processes. So every agency has kind of an appeals board that is that kind of, when the agency makes a decision you don't like, you appeal that decision to the agency's appeals board. If you don't like that, then you can cross over to the federal court system and sue the agency in the court system. But so within that administrative law panel, you use the CFR. That's when you make your arguments based on the CFR. When you go to the district court, it's all based on the USC, United States Code, because you're suing on the statute, but you reference the regulations and the MPP just to bolster your point that my interpretation is in line with my interpretation of the statute is in line with the interpretation of the office, and that carries a lot of weight. So that's how those are used. When you're arguing with the examiner, it's all MPP. You just say, look, MPP says this. And examiners say, no, the MPP says that. That's where the argument is, because it's a very practical one. You're trying to figure out, did I file the correct form, right? And so things like that. Did that answer your question?
Yeah, I think so. I think I learned a lot there. Yeah, thanks a lot. Well, I may have another general question, like just something like, how do you balance, broad patent protection with like a prosecution efficiency, if that's a good question.
Yeah, the question would be, so is it worth it to spend additional time at the patent office to get a broad scope patent as opposed to get a narrower scope patent but get your patent a lot quicker? And the answer is yes. That is, we do both, right? So that continuing practice that I was talking about, I file a giant. Let's kind of step back. Also, it all depends on if you're a legacy company like Pfizer, or if you're a startup company that just got started. You haven't even gotten to asking money from your uncle yet, right? All of these people have completely different patenting strategies, and they draft their applications completely differently. They draft their claims completely differently because they're positioned in the market completely differently. That sword and shield thing that we talked about on the second slide, the way these companies use the patents as sword and shield are completely differently. So you have to design the patent for them based on how they're positioning themselves in the marketplace. So for like a startup company, what we do is we put together. I mean, this is again, this is like the general practice. There are a gazillion exceptions to this, but generally, you draft a really, really big patent application. You put the whole kitchen sink in there, but then you just claim what we call a picture patent, a picture claim. Meaning what? Meaning that if I were to take a picture of the invention and then just claim that with no additional everything, then that's the narrowest possible claim that you can get. Then I get that really quickly. Why? Because I say, look, I go to the investor and say, look, the core invention's patentable here, but I have this patent application that can potentially claim all this other stuff through the continuing application that I have. So then that becomes a very, very powerful tool for fundraising with the VCs, because they first see, okay, it's patentable, and it's potentially much more patentable than this. So again, I mean, you ask a very good question, but that's a question that doesn't have a general answer. It really you really need to tailor the strategy of what you put in a patent, what you don't, what you claim, what you don't, when do you file, all that stuff. You have to really take the company's needs into account. So I just say one more thing, and I've been talking too much, but a patent is not an end in itself, right? You don't invent something to get a patent. You invent something for another reason. You invent it because you want to cure people. You invent it because you know, you want to have a better computer. There's always a technical reason or business reason for the invention. The patent is a tool that allows the CEO to realize that goal. So you never let the patenting tail wag the technology dog. You, as a patent lawyer, you always sit back. You say, you tech people, business people, do whatever it is that the market is requiring you to do, and then I come behind you and I patent it. Not that, hey, I'm going to patent this and then you should build a company around my patent. No, that never works. I do say, hey, this thing that you did, as far as patenting is concerned, is incomplete. I need these 3 other data points to get a good patent, and so they do that. But that doesn't define the course of the research. The course is defined by the science and the market. Hi, Chinga.
I have a question about the CRISPR patent. So it's divided right now between Berkeley and the Broad Institute. Berkeley has everything that's not human, and the Broad Institute has everything that's human. I heard that they're going to be reunited here soon, back under Jennifer Doudna. But if patents have a short life, and both universities said that they're doing this as a protective patent so that people don't misuse CRISPR, they can only do that for a certain amount of time. What happens when the patent runs out?
There are additional patents that are filed as the technology moves forward. So the patents that expire, their technology also become kind of passe.
Yeah,
So,
I,
so,
I don't
so
I don't know how to ask my question because I don't understand it. But they said that both of them said they'd done a protective patent, especially the Broad, because they didn't want people CRISPR editing humans. And but since then, there's somebody had a presentation. There's 150,000 patent applications on top of that original application. So I don't know if the Broad has a license agreement or they have a patent.
yeah, I don't know. I don't know who owns those patents. I don't know much about the the CRISPR stuff. Sorry.
Okay.
I mean, I know the technology. I don't know the patent saga. Any other questions?
Well, if there's no other questions, another general question, maybe like how you bridge the gap between theoretical, you can always ask this theoretical, patent law and practical applications.
Well, that's just practice, right? I'm not really sure how to answer it. It's basically that's what you learn as a brand new lawyer, right? You go in there and you're like, all right, in law school I learned the law, but what do I do now? And that's when the senior associate gives you a document and says, all right, make this one look like this one, and then you're like, ah, so that's I'm not joking. That's exactly what I was told by the partner. First day I showed up to work, he says, you see these 3 pages? I'm like, yeah. You see these 200 pages? Yeah. Make this look like that. I'm like, okay. And so that was that was the all the training I got. That was all the instruction that I got. And the associate told me, the senior associate told me, well, in law, the training methodology is the bad dog methodology. I'm like, what? It's like they tell you to jump, you jump, and they say bad dog, jump, and then you jump again, bad dog, jump, and then you jump, and nobody says anything. And you're like, ah, so this is how I'm supposed to jump. Yeah, so that's how you learn how to draft arguments. You learn what arguments win, what arguments don't win. How do you make a argument that you don't think is going to win, make it winnable? Yeah, I mean, basically lawyering skills come into play.
May I ask a layperson question?
Absolutely. Yes.
So, I think somebody asked about patents uh, expiring or running out or what have you, and then the technology becomes available for misuse. And I think the answer given was that there'll be newer technologies or upgrades, and the upgrades will always be patented. But what if it gets to a point where the passe tech is actually already pretty good and it's good enough to misuse already, so it's not relevant whether they have access. The new patents on the upgrades are active or not, unless it like expires and it can't be used again. But people that want to misuse it can find ways to copy it and use it, can they not?
I'm not sure what you mean by misuse.
I
Do,
mean, in
do, do you mean just use the invention that's disclosed in the patent without having a license to the patent?
no, I don't
Is it
mean
is it ethically misused? Maybe.
yes.
Um, okay, so now repeat your question.
Well, I think in the case of CRISPR, it's more of a back end right after it's misused. So kind of like what the Army does with new technology. All those Army guys have an eighth grade education. You can't trust them. So you just promise to put them in jail once they're out of the Army if they reveal any new military technology. So with a CRISPR patent, they'd have to do patents all across the world in every jurisdiction. Of course, they can't do that. They can just do the best they can, and if they find a misuse, like they've been using CRISPR in China, they can try to sue China, but they probably won't be successful. They're just trying to make the protection aspirational, I guess, and as good as they can make it. But CRISPR's already been misused. Like I can do it in my garage if I want to.
So misuse carries with it a moral and ethical component, and patent law doesn't protect against ethical and moral issues. It's basically for a limited time you can't copy this. But once the patent expires, then that information is in the public domain. Nobody owns it anymore, and so anybody can use it for their purposes. I don't know if that answered your question or not.
It did, and it also sent chills down my spine, but okay.
Well,
Yeah,
yeah,
I think again in this case is if somebody made it like I can make a kit for CRISPR, right? Because you can just amplify the things in PCR in the lab, and then I sold it to some terrorists or whatever, and they prove that I sold what was their intellectual property, then they could take me to jail.
yeah, but you can also go set up a lab in South Sudan and do that. You don't have patent protection for CRISPR in South Sudan, or you can go to
Yeah, no,
Pakistan, which
I
has a first world university system,
I-
and
it's just
and
that
do
it's
that
aspirational.
there. You don't have patent protection in Pakistan.
Yeah, it's just aspirational.
Yeah. Yeah, yeah, it is. And so this is why I I I'm not as a patent professional qualified to define what is use and what is misuse. I can only define what is legal and what is illegal. Personally, I can have moral and ethical questions about something, but not professionally because the law doesn't require an ethical use of an invention for it to be patentable, or to grant a patent only for the ethical use of an invention.
Yeah, that's scary.
How so? Why is that scary?
I mean, because the question that like someone asked and that sort of got me to ask a follow-up was, can anybody use it to do whatever they want then once it's in the public domain, right? And if there's no like laws protecting or regulating how it's used, now I don't know if there are or there aren't, but if there aren't, then that's quite scary.
So the question is, at this stage, what I'm answering is not whether there are laws around that can prevent against the unethical use. I can only say that patent laws can't be used for that.
Sure.
Yeah, other laws can be. Any other questions? So, Austin, if somebody combines two IP protected things to make a new thing, they can get a patent on the new thing, but they cannot practice the invention because they will be infringing the patents on those two things. And so this is a situation where we call blocking patents, because clearly what you've done is preferable to what they have done. Otherwise, you wouldn't have done it. So they would want to convert their product to match your patent, but they can't. And so this is a blocking patent scheme, which lends itself to a situation we call cross licensing. The two sides give licenses to each other, or they don't, and they're assholes, and they go and sue each other, and then the court says, fuck you both. You sit down and come up with a cross license scheme. So the court forces them to settle the case with a cross license. Because the court wants the best product to get to the market as soon as possible. And the court doesn't care who's doing it. They want the market to enjoy the benefits of the product. So they force the parties to find the quickest way to bring the product to the market. That's actually a very interesting thing. We do that quite a bit. If we want to negotiate with a company and they're saying, go away, we don't like you, we have our technical people come up with a viable next generation of the product, and we patent that. And we go tell them, and so they're like, oh, okay, now we're going to talk to you because we want that patent. Once that strategy was so successful that we basically wrested the control of the company from the original people because they couldn't find a way to commercialize the improved product that we patented. And so we told the management, go away. And we came in, and I was just a lawyer. Our technical people and CEO and all that did that.
I think I'm in the matrix. Well, if you can hear me, Sam, maybe another one is for pharmaceuticals. I think you're involved with. So how would you handle patent, prosecution for combination therapies? That might be another question, if that's relevant.
Oh, yes. Combination therapies, your biggest issue is obviousness, because if drug 1 treats disease A and drug B treats disease A, it would be obvious to combine them. But we'll talk about this when we get to the obviousness, section 103 section. But if the combination exerts a synergistic effect, meaning that it's greater than the additive effect of the two, then that's unexpected results, and that unexpected result renders the combination patentable. So for combination therapy, it's all in the search of that synergistic effect to get it patentable. So the patent examples, the example that I have in this presentation, that's combination therapy oxybutylene and pilocarpine, or tolterodine and pilocarpine. All three drugs are off patent. The newest of those drugs is oxybutylene that came into the market in 1984. So by the time we were working on this, it was like way past its patent time. But you see that the combination therapy was patentable, and all because of the unexpected results, both in terms of synergistic effect and the fact that scientifically it was also unexpected that you would get the results that we got. Okay, if there are no more questions, gonna close this down. Thank you very much for attending the session. Hope you got something out of it. I hope to see you guys on Thursday at 2 o'clock Mountain Time for Eastern for the chemistry series that Shamash doesn't like. And also Friday at 9:30 a.m. Pacific, 12:30 Eastern for John's Biophysics. I'll see you guys next week for our conversation on sections 101 and 102 of the patent law. Okay, I will leave you with a song by Sonny Landreth, native of New Orleans. Name of the song is Somebody Gotta Make a Move. It's 4 minutes long, and after the song's over, the room will end. Have a great day, everyone.